Hello, I am Allison Mata bringing you our special coverage updates from Karen Reed, Richard Allen, and of course the ASAP Rocky verdict, which is in. Bob will be joining us shortly. So, I guess it was, if those who don't know, the ASAP Rocky was not guilty on all counts of everything. He did a flip into the crowd, like over the rail to his mom. The whole courtroom was there was no um maintaining their composure when the verdict was read. So, and it sounds like, based on the polls that I've been seeing, that this is in line with what most anticipated, expected, and thought was the right verdict. So, but yeah, it was a sight. It was a sight for sure. So I did pull all of the Karen Reed filings from today, the federal filings. Not going to read them all because they're all the legal arguments. But what I will do, so for Karen Reed, we're going to discuss her federal filings, the the scheduling that the court put forth for when the state has to respond and when they're going to rule on everything. We're going to discuss what happened today in court and Judge Cannoni's um show, really. She was quite the drama queen today. So we're going to go through all of that, see if we can figure out if there wasn't any ethical violations based on the little we know. We have to remember we don't know all the facts. And then with Richard Allen, I'll give you an update on the judge's ruling on the motion to correct errors, but I'll wait for Bob to do that. So what we're going to start with is Karen Reed's, let's see, let's go here. Karen Reed's federal habeas corpus uh, petition. So this was filed today. We're going to go right to the brief here. Let me just see if this changes when you guys, if I change screens, if that changed. Okay, it did. So the petition is sort of bare bones, like the actual petition itself. It's just like, this is a petition, and that she's claiming that her April 25th retrial violates her federal double jeopardy rights. And then the questions presented to the court are here, but we're going to read them from the petition itself, or from the memorandum itself, the brief. So there's the form petition. This is just a form petition to get things started. Then they also filed a 35-page memorandum of law in support of petition for writ of habeas corpus. But what we're going to look at is the brief and go to the questions presented. So this is a statement of the issues presented. It's exactly what they are asking the court to rule on. Nothing more, nothing less. So one, and I'll make this bigger. Issue number one: whether the jury's final unanimous agreement following trial that Miss Reed is not guilty of counts 1 and 3 constitutes an acquittal for double jeopardy purposes and precludes retrial on those counts. So that is issue one. Issue two is whether Miss Reed was alternatively entitled to a post-trial inquiry to substantiate her claim that the jury acquitted her of counts 1 and 3. So that was bringing the jury back in and asking them, did you guys all reach this determination? Was it final? Was there anything else for you guys to do? Were you firm on not guilty on those counts? And 3, whether there was manifest necessity to support the declaration of a mistrial on counts 1 and 3, where 1, the jury was not deadlocked, and in fact had reached a unanimous agreement on those counts. 2, the trial court provided no opportunity for Ms. Reed or her counsel to be heard regarding the declaration of mistrial. And 3, the record reflects no consideration of alternatives to a mistrial when in fact such alternatives existed and were codified in Massachusetts Rule of Criminal Procedure 27B. So the rest of this is all legal argument. What I did do before because I started with the memorandum. So before I realized that they also filed a brief and a memorandum. So I searched the memorandum for the words insufficient or sufficient, trying to see if they somehow, even though they couldn't now because they didn't already do it in the lower court, raise the insufficiency of the evidence argument that I really wish somehow could have been incorporated herein. I searched it again in the brief itself, and the only place that it came up in these 664 pages was in the exhibit that is the lower court's ruling, the appellate court ruling. So that's what was filed. And now to the scheduling order. So this is already the Supreme Court's first order on this. On February 18th, petitioner Karen Reed filed a petition of writ of habeas in this court under 28 U.S.C. 2241. She contends that her retrial in Norfolk County Superior Court, scheduled to commence on April 1st, 2025, after the trial court declared a mistrial on July 1st, 2024, will violate her Fifth and 14th Amendment protections against double jeopardy. It should probably also indicate her state, the state statutory double jeopardy. Okay. Anyway, petitioner is charged with second-degree murder in violation of Mass General Laws 264, Section 1, Count 1, manslaughter while operating under the influence of alcohol in violation of Massachusetts General Laws 265, Section 13 and a half, Count 2, and leaving the scene of a collision resulting in death in violation of Mass General Law 90, Section 24, 2A and a half, 2, Count 3. With just 6 weeks until petitioner's retrial is set to begin, the court issues the following scheduling order to provide an expedited timetable for briefing and argument on the contested issues. 1, respondent shall file an opposition brief by Wednesday, February 26th. So that's right around the corner, February 26th. Petitioner shall file any reply brief by Friday, February 28th, and a hearing shall be held on my birthday, Wednesday, March 5th, 2025 at 9:30 in courtroom 10. And that's in the United States District Court. So that's what's happening there. There are no cameras in the federal courtrooms, so there won't be anything aired. But typically in federal court, they do make the audio available. I don't know if they'll do that at the district court level or not. So we will have to see. But this is all going to happen very quickly. I have to say, I'm not holding out the strongest. Oh, and that's why it only says, sorry, that's why it only says under the Fifth and 14th Amendments, because I'm forgetting this is federal court, this is federal law. The Massachusetts Constitution is not at issue. But I just don't anticipate the federal court doing anything different.
Did you look at the habeas?
I did.
How is it?
It's very, very long. I went over the 3 issues presented with everybody already. So we went through the 3 issues that are presented, and then we went through the scheduling order of when the court wants responses and when the argument's going to be.
Holy shit. It's 700 pages long.
Well, yeah.
The memorandum. Well, that's with the record, I'm assuming, right?
Right. Yeah. This has got, let's see, there's a.
Who signed off on it? Weinberg. So Marty drafted that up. I was gonna say, there's no way Jackson
I
and
already
Nettie had enough time to do that.
did I already pass the where'd you see the signature page?
Are you in the memo? Memorandum of law?
Oh, no, I'm in the brief. Okay.
It was on page,
In the record.
wait, that's not the writ? Is it?
Oh, this was their petition to
Yeah, that's the wrong thing.
okay, so those were the issues presented.
Wow, you didn't even read the writ of habeas corpus? Come on.
No, I did, and those same issues were listed in there, so
I'm gonna go ahead and say you didn't.
no, wait, I'm looking at the wrong thing right now. I did.
I see this. Um, yeah.
No, because I read the issues presented, and it only talks about the federal law, so this is definitely where did I go?
It doesn't even look like that, Bay. It's a memorandum in support of the petition for the writ.
I have the memorandum is over here.
Let's see.
Cool.
Enable scrolling.
Where was I?
Yeah, because the memo is not even laying out, like, it doesn't look like an appeal where it's laying out the issues presented. It's got the procedural background. It's
Yeah,
got,
you're right. This is the record, so it's the brief in the state court. So, all right. So here's the memorandum.
Miss Reed is entitled, so they go why they have standing in federal court, which you might find of interest because you were
Well,
you were not sure if they were going to be able to do it.
interlocutorily, right? I
Yeah.
wasn't. Well,
Do you have
well,
it?
then I go back. It's up.
Oh,
Like, weren't you looking at it?
no, I was
So,
looking at it off screen
oh,
on
so
my
what's
own.
strange is if this is the brief in the state court, then why are the issues presented, don't they mention violation of the state constitution? Wait a second.
Yeah, the writs on actually, pre-printed form.
Yeah, I
And then
pulled that up. I pulled that up for everybody already.
yeah, because I'm still not seeing that you have the memorandum up.
I know I switched back just to read the I don't understand.
I don't understand either. I mean, I think that's a whole separate live though.
No, I know, we're never reading the 700 pages, so you can just forget it.
Okay, the memo is actually only 35 pages. So, like you said, the record's attached.
Right.
Like the balance of it after the 35 pages is, I mean, they're not you writing 600-page documents.
Stop, Bob.
Oh, sorry, babe. Yeah, so it's all the record. The record.
I know, I'm just trying to figure out where I just read the issues presented from, like where I just read that from. All right, whatever. It's bizarre.
Yeah, Marty was busy putting this thing together that quick. The ancient right to a jury trial. Mhm. Yeah, because I think what the first thing in the record is their um was their petition for relief.
Yeah, it's just what I don't really get is where I just read. I'm so confused.
I can't even see what page you're on. All right, well, whatever, dude. Let's move on.
Let's
Like,
move on.
now's not the time to figure shit out.
Right.
We got people in here.
Okay.
Because I'm not that confused about it. Like the memo, and then you've got the appendix, like after it, and the first thing in the appendix is their petition that they filed
Right.
for the
Well, then
judicial court.
so the issues raised in here, they are identical to wherever I read them from. when we read the issues raised before, whether the jury's unanimous conclusion following trial that Miss Reed is not guilty on counts 1 and 3 constitute an acquittal and preclude reprosecution. 2, whether alternatively the defense is entitled to a post-verdict judicial inquiry to determine whether the evidence supports the jurors' representations as to having acquitted Miss Reed. 3, whether reprosecution is independently barred because there was no manifest necessity to declare a mistrial on counts for which the jury was not deadlocked. And 4, assuming arguendo, the court found that counsel consented to a mistrial, whether the defendant's personal consent was required. So those are the issues presented in federal court.
Wait, go up. What was it? I'm trying to see. I think you saw it in the
Doesn't matter.
I know, but yeah. Oh, well, there were actually where you saw it was in the table of contents and the petition to the Supreme Judicial Court. So under their memorandum of law, they outlined with 3. It's on page 41 of the 699. So, but they only had 3. They added that 4th one.
Right.
Yeah.
All right. So in any event, this is the actual scheduling order from from the district court, so that remains the same. But I did, as I mentioned earlier, search this memorandum, and as I expected, there's nothing about trying to squeeze in now an insufficiency of the evidence argument that wasn't raised initially. So, all right. Before we move on, why don't you tell everyone your response to, we already discussed the verdict in ASAP Rocky. It was as you expected and what you think was accurate?
Yeah. Yeah. I thought that it would come back NG. You know, it's like they couldn't meet their burden. Like that wasn't like again, like I don't know if it was a real gun or if it was a prop gun, but what I know is that the state didn't meet their burden. Like, so I don't know if he's innocent, but he was definitely not guilty.
Right.
You know, so it's like
That's the way I felt after OJ Simpson. I was like, I don't care. I think he probably did it, but he is not guilty in a court of law after that bullshit you just saw right here, right now.
that shit show.
Yeah.
God.
Racist cops, evidence appearing out of nowhere.
Oh, the Furman thing was just what a death knell. What a death knell. Because we watched that thing. Like or at least I did. Did you watch any of it with me? The most recent.
Yeah,
Like,
where he admitted it to his friend.
yeah. Yeah. At the end.
Spoiler alert.
Yeah. That really is. That's like in the
I
last
know.
10 minutes of the last episode.
Somebody strike that from the record.
Really blew it, babe. But yeah, no, I felt and it was, I loved watching the ending of it. You know, it's that moment in time that only defense attorneys know when you're standing there with your client and they're waiting for the jury.
You just watched it with ASAP Rocky.
That's what I just said.
Oh,
that's what I was talking about. Like, because you could see because they did something unusual. They polled the jury before they read the verdict.
I was gonna type right before they read the verdict that maybe it is not guilty, because I'd be shocked the judge did that on a guilty verdict, because you need to hear the jury say it is their verdict after they announce guilty. Like, okay, guilty is the verdict. Was it yours?
Yeah. And he did you see it? Like after they read the first NG, he like ran back and like dove into Rihanna's arms. He like
Oh, is that
dove.
who it was? I thought it was his
Yeah,
mother,
no,
his wife.
it was his
Okay.
wife. Yeah. Um, and then they're like, "Hey, yo, man, there's 2 more counts. You gotta bring your ass back up here." So he came back up. But like in the seconds preceding reading it, like I'm looking at his back. Like Rocky's a thin guy, so he's got like in the back of his suit coat, he's got like you can see his shoulder blades and you can see his breath like while they're like preparing to read the verdict, and it's like it's that thing that we're always trying to explain to everyone that that moment in time that like when you're waiting to hear what the jury has decided is so tense. There's no other thing like it. Like that, I've tried to think of other things that are the equivalent to that moment in time of a verdict being read, and you're standing there with your defendant, and it's like the other thing I was thinking is like that embrace from Rocky to his lawyer Joe. No prosecutor's ever feeling that. You just can't
Right.
like there. You just can't. It's because it's like I mean, victims' families will
Yeah,
hug a
it's different.
prosecutor.
They get a
Different.
different
It's different.
it's
It's just a
something,
different
it's just
thing.
different.
Yeah, it's something. It's just different. It's just really
So, before we go to Karen Reed, because that's what we're gonna spend most of the time talking, why don't you reveal the all suspenseful ruling of the judge on Richard Allen's motion to correct errors?
denied.
Oh. Do-do-do-do. Denied without hearing.
Yeah,
Now,
everyone saw our tweets. I
d
mean,
do we think is she never ruling on the preservation motions and
well, so what she did, she denied, I think, 4 today. The one that she did not deny was the most recent filing, which was the motion to preserve the Reese
that's what I figured.
Davis. So that one, I think it looks like she's gonna require McClellan to respond.
You're saying
So
that because she hasn't denied it yet.
yeah, right. I mean, why wouldn't she have just denied it with the other ones?
Right.
I
And
mean,
she
she had
said
the weekend. It was 7
that
pages long. It's not like she couldn't
she's
have read it.
yeah, she said the defense cited no statutory grounds for preserving evidence, so she's denying it.
Well, initially, their initial um, motion to preserve was
Overly broad.
overly broad. So, she's like, there's no specificity. No, I don't know. But I'm hoping that she's requiring McClellan to answer, like that he's got to respond to it. But I won't be surprised if she doesn't. I mean, her like Osbrook's motion was, as to the law, unimpeachable. Like, I mean, I don't know how she ruled against him. I mean, the rule is the rule. Either you have supporting affidavits or you don't. It was defective on its face because it didn't have the supporting affidavits. Like McClellan just can't say shit and have it be. Like that's not how this thing works. Like you have to have supporting affidavits. So,
Did you see a separate order where she actually denied the motion to strike? Like she said
yeah,
that?
there
Oh,
there were 2 separate orders. So the one order was for the motion to correct error. That was on its own. And then she had a second order. I mean, I have it if you want me to pull it up. Do you want me to pull it up? Renee sent it to me this morning. My
if you'd
clerk
like
was on
to.
top of it today. She I never want to talk shit because she's amazing and she's sending me so much stuff. She's like, "You are welcome. If you don't need me to email you at any time, just let me know." I'm like, "No, just keep emailing me shit." I'm like, "You're about off duty because this thing's about to be in the appellate court's hands pretty quick." So,
All right, I say we just jump into
yeah, I mean I mean, as far as Alan goes, that's where we're at. So right now, I mean, at this point, well, let me ask you this. There is still one pending motion down low, but in light of the fact that she is now denied the motion to correct error, I think they're on the clock for having to get the notice of appeal filed if they haven't done that already, which I don't think that they have.
Yes, yeah.
Yeah. So even though there's that one pending thing in front of Gall, I think at this point it's a final judgment. And I think that the notice of appeal is going to have to get filed. And I'm assuming it's 30 days in Indiana, like the rest of the world.
It might be faster because they had that,
Yeah.
I was trying to move this thing over law and crime. Let's try. How do I move us over again? Why doesn't this stuff work anymore? I don't know. All right. So what we're going to do for today with Karen Reed is just start with the motion that involved the crash daddies as they're, what's the word?
Affectionately
referred to. And we're going to watch what happened today, and then we're going to go back and see some things that took place in other on other court
Oh
dates.
yeah, wait. Did what does our thumbnail say? Did Mandy say it was Wednesday?
She sure did.
It's so funny. When Scout got home, because it was a frantic day. Like I've got Mandy's back like all day on that because you went on with Melanie early, and then I had like a bunch of shit going on, and then I ended up with Michael and Linda over on Justice Served for the verdict. And then I had to jump over and do the Q&A with Lauren, and then you guys set this thing up. But when like Scout got home, I'm like, you got practice today. Because in my brain, it was Wednesday. Like it just felt like Wednesday to me. I don't know why. So it is in fact Taco Tuesday.
And we didn't have tacos.
Yeah. So yeah, let's dig into it. So look, there is, hold on. You talk for 1 second. I gotta get this car real quick.
Okay, he's got to get this car. Is that what the words he just spoke? Thanks, Mandy. So, in any event, what we're going to do is we're going to listen to the argument on that today. We're going to see how the judge responded, and then we're going to go back and look at some, statements made during earlier proceedings to see if, at least what was said today sort of tracks with what we know has happened in the past, and see if you guys think is it possible that it could be considered misrepresentation from what we know right now, because we do not know everything. We only know what we are about to hear. We only know what Brennan said to Judge Cannoni in this argument right now. I'm going to do it and if somebody wants me to slow it down, just say so. We're going 125 unless someone requests otherwise.
Commonwealth's motion to exclude employees of ARCA, paper
Is it loud enough?
497, and the opposition 505. So, Mr. Brennan? Sure.
Man, this shit was crazy.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness.
Did that get louder for you guys? Did you hear any change, babe?
I don't, just play it.
I boosted it and it changed in my ears, but I can't.
It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert.
How's it sound?
It sounds about the same to me.
Okay. Can everybody hear it, or is this not loud enough?
But you have to play it so we can hear it.
Turn down your
Yeah, thank you, Mandy. Crickets.
turn you down, babe. Significantly.
Okay.
A little more.
I haven't turned it down yet at all.
Oh. All right. Well, don't talk and let's see if it got louder.
It's interesting that the defense's position is that the information is unavailable to them. And
Well, no.
Sounds the exact same to
All right,
me.
then turning off the.
The sound effects are cranked though.
Serenity now!
Hold on.
What were you on? Law and Crime? I think that Boston 10. I think that was the best one. I think that was definitely had the best sound from what I heard. Let's see.
Oh. All right. Wait. They did this as like Boston 10 didn't. It's not the full thing. I don't know why.
Yeah, I see the analysis.
Hmm.
Yeah, I see the Boston 25 with the full hearing.
Where is it? Boston 25?
Yeah, let me see if the sound better on this.
Because the Boston 10 sounded great.
Yeah, put on Boston 25.
You do it because well, no, I want to do it. but
Yeah, you got to do it. You got the timestamp.
This is awful. How do I find it?
Just go into YouTube and type in Boston 25 Karen Reed.
All right, Mandy sent it to me. Thank you.
I thought you guys had all this shit lined up while I was.
I did, but on the.
All right, so while they're getting
I
that
got
set
it.
up,
I got it.
okay, but while you're doing that, look at this. Like, if anybody knows Toyo Toys, aka Phil Foss, like he finally sent me this amazing lowrider Lincoln Continental. I think it's a Mark III. Thing is so wicked. It's so cool. I've been waiting so it's got Defense Diaries back there. It's got it on the windshield. It's got it on the wheel well thing there. It's got, if you can see, it's got Just Facts on the door.
Sweet. Now I know what you meant when you said I got to get this car. I was like,
Yeah. It's got DD, Defense Diaries on the top of the windshield. The thing's wicked. So the point of me showing you this, like, here's the deal. When Phil finally sends somebody a custom-made whip that he makes, what we have to do is we run a contest and somebody wins it. Like, I've got to give this amazing thing up.
What? What are you talking about? Why?
Yeah, it's the way it goes. It's the way it goes. It's all part of
All right.
what goes on. So I don't know if we should do it on tonight's live, but what I'm going to do is I'm going to do another wheel, and people will have to enter with a super. I'm going to do it probably like a 20 because thing's awesome. Like, I really don't want to give it away. It's kind of like when Shay made me that version of me. I really don't, I didn't want to, I didn't give that away. I kept that. She worked so hard on it. Like, Phil puts a ton of work into these things. It's amazing. So I don't know. I'm going to double check with Phil and make sure that that's the mandate that I'm supposed to give it off. Like, I mean, we want Phil getting love. Toyo Toys, he does amazing stuff. Like, he does it. He's made a few for Steve, Dan over at PB. They're always awesome. I saw he made one for Gisela and the Grizzlies. She had one. She got like a SUV. Like, this thing is like literally the Lincoln Lawyer. It's like this should be my actual car. I wish I could make it life size and just drive around in this badass motherfucker all the time. Look at that thing. Thing is super dope. It's got the low pro tires. It's just amazing. I don't know if Phil's on here, but the thing is it's awesome. If you are, Phil, thank you. I love it so much.
That he doesn't want to give it away, but we will.
We will.
All right, here we go.
Oh, Shannon, yeah, she got her shirt. Yay. I'm glad it actually worked. I actually sent somebody something that they won, so I'm very proud of myself.
All right, let's go. Ready? If you guys can't hear it, let me know.
With the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can
Oh,
get
wait.
it here?
What?
Was that
Yes,
the
they
date you?
Jesus.
Yeah, Lisa, this is not 3D printed. It's metal. This is like a Hot Wheels. This isn't plastic. 3D printers, as far as I know, are not doing anything in metal, are they? I don't know. Maybe it is. Do they know that? Can they do that right now? Can they 3D print metal?
Have it on or before
Oh,
March 1st.
guns aren't metal either, Mandy. The 3D printed guns, those are not metal.
I'm so confused. Okay.
What are you doing?
I don't know. It wasn't.
I saw OnlyFans. It was up there.
All right.
Sure. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have toward one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that. You have not complied.
So now that was June 10th. That's before the voir dire, which was, I think, June 22nd. So that's what they told the court on June 10th.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. Recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with the retainer as required.
All right, so that's showing some communication. They talked on the phone. He's going to send out a retainer and an engagement agreement, but the next sentence kind of takes all that back.
The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we receive additional information from their office regarding how our involvement will move forward.
All right. So I want to pause this. We need to figure, I want to be clear on the timeline.
Yep.
Because there's three potential issues here. There's failure to disclose this script of the direct whereby he sent it to Wolf. Wolf made comment on it, which included the comment about, I handle a lot of these, and many of the pedestrian strikes are at night because of visibility. That was not turned over. We've got the issue of the money and when that was paid. And then, it's why is Jackson taking the brunt of this? Because it very much seems, without giving, too much of a spoiler, Jackson appears to me to be the one in peril. And that's namely, it can't be Elise. He wasn't a part of the first trial. It's not going to be Eliza Little because she didn't have shit to do with this. Yannetti is a Massachusetts lawyer. Alan Jackson is on a Pro Hac Vice license, which is a temporary license to practice in the state of Massachusetts for only this case. So, and that is the easiest way for a judge to get rid of a lawyer that they don't want on a case or that they think warrants not being on the case, is just you pull their license. Super easy. So timeline wise, where are we at? What is he alleging about?
Well, let's play it out, and then I'm pausing it at the times that he mentions things. So right now,
the first thing he said,
June 10th, 2024, the defense told this court that they could not give any other information because they could not speak to the experts about their findings. And then he showed that they communicated in March, and they were going to send out an engagement agreement and a retainer. But then,
wait, when did trial start? When was the first day of trial?
Oh no.
Somebody in chat, when was the first day
April.
of the trial? Because that's what matters, right? I mean, obviously leading up to trial, that's
April 29th, 2024.
Okay. So April, May, they're into, see, that's why I don't understand the timing of this.
What do you mean?
Because he says they're in June. The trial was still going in June.
Yes, they did this voir dire mid-trial, remember?
No.
Of Russell and of
The ARCA guys?
Yeah.
Rensler and Wolf? Yeah. Okay.
Now, it's not the opinion.
I'm going to go back.
And on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we receive additional information from their office regarding how our involvement will move forward.
So, all right, pause. Any additional communication? Pause. We're back in March.
Okay.
Now,
pre-trial.
It's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
So this is days before he testifies, obviously after voir dire. It's a outline of his D&T depositions and testimony. And we don't know what the full outline is. You know, he's going to get into a couple of notes here. But this is so after the voir dire, but before they testify.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline.
Hey,
Of
so let's look right here. He
an
says
insistent, the
when
best
he
I can. This isn't information provided by the defense.
so he says this is information that was not provided by the defense. And let's look at the lawyers. Why isn't it letting me make it bigger? Oh well. But let's watch the lawyers here.
Reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and
Liza looked at
an
him.
insistent,
Mhm.
the best I can, to get
He's
as much
like, I know.
information as I can.
He's like, I know.
We
She's
then
like,
are provided
an
an
over.
outline
Yeah,
He's
I
like,
know.
of questions and answers for a direct examination. Commonwealth did not have the luxury.
pause
or privilege,
that
did
right
not
there.
even know that there wasn't.
In terms of Judge Cannone, him saying that exact sentence changes everything in terms of whether or not she was going to be willing to hear Alan Jackson argue this today. When he said, like, as soon as he corrected it, she should have said, okay, now that you've said that,
Can we wait until it happens?
what? All
Like
right.
he hasn't corrected shit
Yeah,
yet.
like I want to point out how big of a deal him saying that
Well,
inaccurate
we
thing
can
was.
as soon as he comes in and fesses it up.
All right. It's a big deal. Just pointing it
It's
out
a
right
big
now.
deal.
Big deal.
It is a big deal. He's going to retract this. Spoiler alert.
An outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
All right, she's going to ask the date for that. He's going to say there isn't one. But I just want to note, this is not substantive discussions about his findings, investigation, testing. It's just basically him saying it's going to be nothing. They're going to raise that I didn't, inspect the car personally. I didn't have to.
Right.
Date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting.
See, he's doubling down on the fact that the Fed sent it to him by talking about the TUI request. So it's more than a misstatement.
Correct. Well,
It's more than a misstatement. Saying it one time and
he seems to have believed it, or at least is pretending he believed it.
wow. He's calling it that he got it from a TUI request, which if you all don't know, a TUI request is when you're sending something to the Feds and say, hey, we need this. And the Feds decide if whether or not they're going to send it to you.
Right. So he's telling the judge right now, the defense never turned any of this stuff over. I only got it by the luck of my hard work, badgering the Feds for it.
I'm not saying that undermines the conclusions of ARCA or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors result in a lot of my cases involving pedestrians. Pretty important stuff in this case.
Pretty important stuff in this case. And I note before we're going to play some of the trial testimony. But he said, I wasn't here for trial, but I read the transcripts. So we're going to do some fact checking after we get through this.
And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them.
Now, that could be an issue depending on the context. But here, as I opined when I was on with Melanie Little earlier, this doesn't go to his examination, testing, opinion in this case. It goes to his general knowledge as an expert. So he's saying, you know, if you don't want me to bring it up, I don't have to. Is that a big deal? I don't think so in this context. Does it show some bias that he's willing to not say something that and leaving it to the defense as to whether he should? Maybe it does. Agreed, babe?
Yeah, maybe.
Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
Now, that should have been cleared up. We don't know when he found this out. And I'm assuming, and I guess I could, because I'm going to play some of the trial testimony, that he didn't testify to the wrong number. It was just a wrong number during voir dire. And if this is, you know, a day before trial, I can't imagine any court being like, I mean, technically, yeah, he should have revealed it to the court and given the court the opportunity to say it doesn't change my finding that he is, you know, qualified to testify. But that wasn't really the purpose of the hearing initially. It was so that more of their opinions could be delved into. And also, I guess it was for their qualifications. So the defense should have let the court know. Right, babe?
Yes.
And then a bill from ARCA to the defense for $23,925.
Dated when?
That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I
Really?
care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before we start.
All right, please.
So she takes her abrupt recess. And now, a half an hour later, she comes out.
Was it that long? Is that
Yeah.
how long of a?
Yeah. So it was, what is this? 148? Yeah. Yeah.
The second session may be seated. Make sure your cell phone off, put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at
I
11
can't
o'clock in the
tell if
morning. You
she's
can tell me now
furious.
if that is impossible for you.
If what?
I think she's furious.
Well, that's definitely the way it is coming off. And I kind of said earlier, look, there was 30 minutes that had gone by. You know, is this really anger or is this anticipation of getting rid of?
What I don't. Why do you like Alan Jackson is a consummate professional. He never lost his cool. Like that guy. I don't get I don't get the vibe that like she was dying to get Alan Jackson off the case. The guy is a phenomenal attorney by all accounts.
Well,
I don't give a shit
I
what
don't get it.
side of the
Wait,
Karen Reed thing you're on. Alan Jackson's a hell of an attorney.
correct. But getting one or all of their attorneys off the case, that is a huge deal. And why do you think that Judge Canone's above that? Canone's above that, but the judges in Nebraska weren't above that.
Like, they hated us. Like I mean, she probably has some disdain, which I think pre-trial of the first trial, because of the motion to dismiss and all of the shit that came along with that. And that's obviously, if you don't know, the motion to dismiss they filed, which is what clued the rest of the world into their whole theory, their defense of, you know, the third party culprit and, you know, obviously the cover up. You know, that was born out of the motion to dismiss. So I'm sure that irritated the shit out of her, because then she had to deal with an enormous amount of shit that she wouldn't have otherwise had to deal with. All the stuff with Aiden and the witnesses and all of it. So like, I'm sure that irritated her, but after she made it through the trial, I mean, I don't know if she's still there. You know what I mean? And yeah, they tried to bounce her. They did. They tried to bounce her. They tried to have her removed, saying that she was biased.
Bob, when have
maybe.
you ever seen her from the bench express any sort of opinion? She's here talking about how they have them schlep across the country to look at camera video from the Sally port that doesn't exist. You've got inverted video showing up. She
I agree.
never says a
agree.
word.
I agree.
She was chomping at the bit. And if she's so angered by this, without all the facts, with half a story of undated things.
Well, what bothers me the most is that she didn't give Alan the opportunity to rebut it right then and there. So now she's going to stew on this shit for a week without giving the defense the benefit of correcting what this guy is putting out there. You know, because now she's sitting here stewing until the 25th.
Well, she doesn't have to stew on all issues. Let's continue to play, as you've alluded to this earlier.
And where Mr. Brennan, where the federal
Look at her
authorities
hand
were
shaking.
kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If
Here
I
we
could
go.
add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th, 2025. I think I said the federal government. It was the defense.
So you would expect her to already right then and there be like, wait a minute, this is already not what I thought. And how he makes a freaking huge mistake like that, and he's got the chronology at his fingertips.
And doubles up on it by saying that he got it pursuant to a TUI request. It's one thing, like I said, it's one thing to say the defense didn't send this to me, the feds did. So then, I mean, in terms of being a judge and hearing that, it makes it sound like the defense is hiding the ball.
Right.
When in fact, it's the defense who tendered it. As soon as he said that, she should have taken a big breath.
Right.
All right. Okay. That changes things, counsel. Like she should have admonished Brennan Mr. Brennan, that's a huge fuck up that you made, because it pissed me off to the extent where I had to take a half an hour to compose myself back in chambers and figure out what I'm going to do. So now, in light of that correction, I'm going to allow Mr. Jackson to respond. That's
Right.
what should have
Please
happened
ask
today.
the question of, Mr. Jackson, you testify. You don't have to answer me right now if you need time to look all this over. But you said that you guys did not pay for the testimony of these experts. Did you in fact pay them? Is that bill that he just talked about a bill for their prior testimony? But
So let me just be clear, because I want to be clear, and I think that probably a lot of people in the audience want to be clear about as well. So when were they disengaged from by the DOJ? So the DOJ is like, we're no
you
longer
just said February 6th.
of 2024.
Correct. But
Yeah.
as we just heard, there was an email back in March or after March 22nd that said, hey, the feds told us don't talk to anybody, no more communication until we figure out what our role is and how this is going to work.
So I mean, but there's nothing untoward about. So they're no longer on the DOJ's dime. So when Alan gets the report, he's like, oh shit, these guys are on like they're going to win the case for us. He then reaches out. He says, all right, well, we've gotten the report through the TUI request. Obviously, we want to call you guys. And, you know, I mean, ARC is going to say, all right, well, we've already done the report. You're not retaining us to do the things that we've already done and been paid for. What you do have to do is pay for us to get there. You have to house us, and you have to pay for all those things. I mean, that there's nothing untoward about that. That's not as if they retained them to create the potato gun, the mnemonic gun, and create the reports. Like that was all paid for by the DOJ.
Correct. Correct.
So I don't know.
And just to answer Annie's question here, it wasn't a federal order, I don't think, but they were hired by the feds. So if the feds tell them no, you can't share your opinions for testing that we hired you for with someone, that I mean that's what they're going to do. So it falls to the feds in that sense. I could be wrong. I don't know if Melanie Little is watching and she knows if there was an actual federal order that, but I think that's the case.
That's February 13th, 2025.
Back it
There was
up.
a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025. I think I said the federal government. It was the defense. February 13th, 2025. They sent us the emails and the direct examination outline.
Okay, and the direct examination outline. So all those comments that he said he didn't know, all of that was provided by the defense in February of, let's just make sure I'm not crazy,
We reached
2024.
out to the, I think I said the federal government. It was us. On February 11th, we filed the motion change and present. If either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025. I think I said
Oh, to
the federal government. It was the
2025.
defense. February 13th, 2025. They sent us the
Oh.
emails and the direct
Okay, so
examination outline.
is the issue, we really need to have Rule 14 pulled up, because I've never, like, why would they need to provide the state a copy of their outline direct examination with notes between Jackson and Wolf? Why, in what world do I ever need to provide that kind of shit in reciprocal discovery? Oh yeah, here's an outline of my fucking cross-examination, bro. So you know what it's got. What, like, I don't understand. I'm so confused about this part of it. I was asking you, I'm like, okay, so it's not work product because he's an independent witness. I get that. However, it's still work product. It's now a witness that the defense has adopted and is going to be calling. Why in the world would he feel that he needed to send that to Brennan anyway?
Right. So what they said, I'm reading the rule, that the defense would have had to disclose intended expert opinion evidence other than evidence that pertains to the defendant's criminal responsibility and is subject to subdivision B2. Such discovery shall include the identity, current curriculum vitae, and list of publications of each intended expert witness and all reports prepared by the expert that pertain to the case. So
That's not a goddamn report.
correct. So then we have V2, material and relevant police reports, photographs, tangible
Nope.
objects, all intended exhibits, reports of physical examination of any person or of scientific tests or experiments, and statements of persons the party intends to call as witnesses.
So wait, read that one again.
Material and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examination of any person or of scientific tests or experiments, and statements of persons the party intends to
So
call as
statement
witnesses.
that I only wanted you to read that last part, but I'm glad you read all of it. So statements, like, is that what they think this falls under? So Wolf says this statement about,
I don't think so.
the pedestrian strikes, unfortunately, primarily happen at night. Like, I don't see how this falls under the rule, the reciprocal rule of discovery. I don't see it.
And then the last is disclosure of all promises, rewards, or inducements made to a witness the party intends to present at trial.
Not costs are not inducements. That's
Right.
merely paying. Like like Judge Cannoni cannot expect ARCA to foot the bill to fly in unless she's going to say that. She's like, okay, well, they're independent. Like neither of you are allowed to pay them a dime. If they want to come, subpoena them and haul their ass into court. I mean, but they listed him as a witness.
Correct.
I mean, they adopted them as a witness. So at that point, they're going to have to pay for them to come, and you're going to have to, and it's expensive. You're flying them out. They're here for days. You're putting them up. You're feeding them. All the shit that comes along with 2 expert witnesses of the quality of a couple of doctors with PhDs that work for ARCA. They're not going to be cheap, like in
Right.
terms of, plus
Right.
I'm assuming they have to pay for their courtroom time.
Well, that's the question. That's what I would assume as well, but they didn't disclose that. They said that they didn't pay for testimony. So that's what if they did, then this is an issue. Hold on, let's finish this and then I boot up the next thing.
We reach out to the federal government again because I was curious about the change in position on February 6th that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from
That's February 6th
obtaining
of
them.
this
So
year,
we've
right?
refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock, a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Here, if I may hand up the discovery that was
Thank you.
provided by the defendant reference by.
Oh, great, thank you. We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th, even if you're.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is.
So I'll just note that shift that he can appear via Zoom might be indicative of her taking that breath and realizing it's not all she thinks it is.
Right. Because I think your first initial reaction was like, oh shit. But I think you were originally like, you or Melanie was like, oh, well, that's not good. Like, she's like, we don't even need your ass. But I think you came back and you were like, well, if there's going to be an evidentiary hearing, she's going to need him there in person if
Right.
if she's going to expect him to essentially have to testify.
Right.
Which, if she's going to seek, and that's the thing. That's really the thing about this is that with the pro hoc, she doesn't need to go through all that shit. She could just pull his license, his temporary license. She doesn't need
Well,
to
she
go.
still needs to find that he violated an ethical rule, that he did something to warrant. She can't just pull it without any sort of
Well, I mean, without the Sixth Amendment ramifications are substantial.
right.
I
And
mean,
she would need to find that there was a violation of their rules, that he did something to warrant that. But let's keep going.
I scrap today's court schedule. If we can do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
Ma'am, just a moment.
Thank you.
Oh, Karen, what? Arrgh. It's like, why don't we
Your
just
Honor,
tell
we'll
her right now?
accommodate the 25th, one way or the other.
All right. So we'll see everyone.
I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock
Wow.
on the 25th.
Thank you.
Oh. So she did not change her tune because she wouldn't even entertain Alessi's motion. So
no, she
and like-
didn't change. She killed the day. She suspended all of it. You know what's interesting is, when did he get that shit? He said he got that stuff on the 13th from the defense.
yeah,
So it's after he filed. So he filed the ARCA motion in early February, I think. And on the 13th, he gets the set of emails from Jackson. And like she's basically acting sua sponte at this point.
she
Like,
is
if-
acting
if she-
sua sponte. Yeah.
Yeah, if she's contemplating pulling his ticket, then she's doing it on her own motion because Brennan didn't file anything. I mean, he certainly, based on what he argued, he certainly could have filed a motion articulating that he thinks that sanctions are appropriate based on the discovery violation. But he didn't do that. Instead, he ambushes them,
Right.
which is there's no other way to look at that. Like, he completely ambushed Jackson by not filing. I mean, if you file the motion for sanctions, you're giving them the heads up. You're giving them time to prepare. Instead, what he does is he stands up and says, "Oh, I don't give a shit if ARCA, those guys get on the stand, and I don't care what their opinion is. What I do care about is that they're not playing fair." And then he goes into his whole diatribe and lays out his timeline about what they didn't disclose. Yeah, I mean, it was crazy. It's crazy.
So
But
let's do a little bit of fact checking here, but I'm going to actually start with the 27th. So this is the day that they're doing the voir dire
of Rensselaer and Wolf.
and Russell, but yeah.
Unusual in terms of the timing of it.
So the understanding of the voir dire is this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation.
Is that the same with Dr. Wolf and Dr. Prince?
Well, I thought that would help both of you. Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
That's correct.
So I want to find out if they have any credible, competent evidence to put forward. So we'll have a voir dire on them as well. But
So
for
that-
Dr. Russell, what we're doing here today is there's an alleged violation. This appears to me to be a violation of the.
So that right there, again, he said he wasn't able to talk to them about the case. So talking to him about his, his background, his deposition and testimony and other cases, and we don't know the uh
The date of the direct examination when that email went through.
yeah, but day 27 was gosh, I forget what I think it was June 24th. Let me see if I can figure it out.
Well, do we know what the date of that the script of the direct examination was? When was that?
He said that that wasn't dated.
Because that would certainly be talking about the case.
So June 18th is the day of this, and we know that his comments were after this. So I take that back. We know that because he mentions the fact that there was
Oh, he said you did a great job on your questioning during voir dire.
right.
So that's how we know that that's after this. Okay.
Right.
So that fact checks.
So now I'm going to go to some of the questioning.
Come to conclusions and opinions to a reasonable degree of science and certainty.
I was, yes, sir.
You were not hired by the defense, by me, or anybody on the defense side in this case, correct?
That's correct. I was.
I'm going to slow it down.
Correct?
That's right. See if I could determine what happened, how the injuries occurred, and the events leading up to and during that process.
Without going into your conclusions and opinions, were you able to come to conclusions and opinions to a reasonable degree
I
of science
backed up a little too much.
I was, yes, sir.
You were not hired by the defense, by me, or anybody on the defense side in this case, correct?
That's correct. I was not.
You were not consulted with or hired by the Commonwealth either.
I was. That's correct. I was not.
It was a completely independent agency, is that right?
That is correct. Yes, sir.
Before this morning, have you and I ever met?
No, sir.
And we've never talked about, you and I have never talked about the substance of your opinion and conclusion, correct?
We have not. That's correct.
You did reduce those opinions and conclusions in conjunction with your team to a report, is that right?
I did. Yes, sir.
And your understanding is that report was made available both to the defense and the Commonwealth in this case, is that right?
Yes, sir. That's correct.
I have nothing further.
Okay, Mr. Lally?
And I'm going to let it go because
Thank you, Aaron.
it's a couple of relevant questions here.
Objection.
A few questions for you, sir. Good afternoon.
Good afternoon, sir.
Now, with relation to your work in this instance, in this case, were there any limitations as far as confidentiality or anything that were put on you or any of your team?
What do you mean by
As
confidentiality?
far as who, what, where, and how you could discuss what you did?
Well, yeah, I mean, certainly we just discussed with who we were retained by in this case. I don't believe I discussed the case with anybody else except for my cohorts who were also involved in the case.
And so my question, sir, more is geared towards, at some point you were made aware that your report and your findings were made available to both the prosecution and the defense in this case, correct?
I was made aware of that, yes, sir.
And when you were made aware of that, was there any limitations on given to you as far as who you could discuss your report, your findings, or anything with?
Yeah, basically given the direction or the request that I don't actually discuss the substance of my opinions or my report with anybody aside from who we were originally retained to work for.
Now, may I approach, Your Honor?
So there's that. He's saying the same thing. They weren't allowed to talk about the substance of their report.
Travis says that the email said that it was a retainer, not for cost. Is that true?
The email said, I'm going to send you an engagement letter and a retainer. And then the response was, hold up. We're not going to do anything. Can't talk about this even any further until we get direction from the feds about what our involvement is going to be. So it's sort of, in my estimation, it basically undid that earlier email. But in the first email, he says, it was nice talking to you on the phone. going to get you out an engagement letter and a retainer as required.
Now, was that after voir dire? Was that after
No,
this?
no, that was back in March 22nd of
So, because that's
2024.
what I was trying to clarify when they said, when Brennan was saying that they were no longer being engaged by the DOJ in February 6th, was that February 6th of 2024 or February 26th of this year?
I think it was I thought it was all 2024, and then he started saying 2025. So hold on.
Because what we know for a fact is that the DOJ isn't paying for any of this shit in terms of the trial, the voir dire, flying them out, housing them, feeding them. That's not going to be on the DOJ's dime ever. So
I'm just going to check what he said.
what did the email when the
Hold on.
23 grand got sent, what did that call it?
So he starts with the brief chronology. December 4th, 24.
December 4th of 24, what
They sent
happened?
another 2-way request.
The defense
January.
did or
Hold on.
Huh?
Just what were you asking?
What is that date? December 10th?
I'm re-going over what Brennan said to the judge. So it's the prosecution sent another 2-way request December of 2024.
Yeah, okay.
Okay. January 30th, 2025. They send the U.S. Attorney's Office sends a response without any prompting on February 6th, 2025. They received that email about not being retained by the government anymore. Good?
Yeah. I mean, I'm not just doing it for my benefit.
No, I know you aren't. I know you aren't.
Yes.
Sometimes it seems like you think I am.
No. Okay, so that again was questions during the voir dire. So now let's just do trial testimony. Now I'm going to go back and we're going to replay this real quick.
So was Wolf's answer substantially similar to Rensselaer's in terms of, we didn't retain you?
He
And-
wasn't asked that on day 27. Not Wolf. So that, at least from what I gathered from the transcript. Hold on a sec.
No, we know that's not
You had a
Wolf.
lot of nighttime visits.
Alicia. She said that Wolf didn't testify to the same thing that Rensselaer did about not being retained during the voir dire. Remember, that was voir dire. Now we're going to the actual trial.
Well,
let's-
right now I'm going to this comment that Brennan highlights, saying he wished he would have known.
Disability work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have.
All right, so let's go to the trial.
Oh, am I going to get to say gotcha? I feel like I'm going to get to say gotcha, maybe.
You are, and
Yeah.
all right, hold on. Okay. That's direct examination. And I did want to note that who was it? Brandy Churchwell posted that today. Like, oh, okay, they didn't know this. Word for word, he said it at trial. So I don't know because Brennan said he read the trial. So I don't see any issue there, especially because
Wait, I thought you were gonna play it from trial.
I just did.
Wait, no, you did. We didn't see shit. It's still showing the Brendan.
Oh,
What the hell are you
Jesus.
talking about?
Sorry.
Wow. I mean, I would have said gotcha. It was still hammering Hank over there.
All right.
Captain
Sorry.
Nasal.
Listen, you're gonna have to listen to me for 4 months in my incredibly nasal.
I was listening to it in my ears.
Oh,
So
sorry. Yeah.
I
Sorry,
didn't
not
think anybody
sorry.
else wanted to hear it, I guess.
No, everyone wanted to hear it.
I got it.
Trust me.
All right. Okay. This is direct examination.
Got to share it.
Wait, are you saying I still didn't share it?
No, we're not seeing shit. Like,
Oh,
oh,
Lord.
see, if you would use a second screen, you would see what was going on. You don't have StreamYard up, so you can't see that it's not sharing with us.
All right. Sorry.
You've got like two giant Thunderbolt displays in front of
All
you.
right. Here we go. This is it. This is direct examination.
Field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
All right.
So was that direct?
Direct examination. Here we go.
Done testing or research as
There, just to prove it was direct. There you heard Alan Jackson.
Okay.
Oh, now we're going to go on to other discussions about the conversations, money.
I mean, but that doesn't cure the argument that the Commonwealth didn't know about it before he said it.
Well, it definitely cures the argument that they were trying to hide that fact, that it was a fact that wasn't helpful to the defense and they hid it.
Well,
I don't think it was discoverable
but this
in
is
advance.
trial.
I know, but I don't think it was discoverable in advance. It's not part of his, examination of his testing or his opinion.
Well, and beyond that, you don't have to work for fucking ARCA to know it's harder to see people at night than it is during the day. Like I'm no scientist, but I can tell you it's way harder to see people at night than it is during the day.
Right. All right.
instructions, is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf,
At the time you did your expert review, Dr. Wolf.
in your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Mr. Unetti.
No,
Matter of fact, you'd never heard of this case.
that's correct.
You were hired by another agency not connected in any way to the defense, is that right?
Correct.
And not connected in any way to the Commonwealth, is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case, is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You had never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
About your testing before today.
So,
Any issues yet?
I don't know. I mean, I'd have to see the totality of the direct examination script.
Agreed. Agreed. But based on what we know right now, this note in the footer or in the margins of, it's not unusual that I don't see the the vehicle, and they're going to try to make a big deal out of that. That's not a big deal. Do you think that falls directly into talking about the substance of their testing?
I don't know. I mean, but as far as that goes, I don't give a shit because both sides got the exact same goddamn thing. Both sides got the exact goddamn things. Reports both went to both sides. Like, you know what I'm saying? Like,
I don't see how it's something they needed to tender in discovery that he said it's a non-issue that I didn't inspect the vehicle.
I agree. I agree. I mean, that's just typical expert witness shit. I mean, defense experts rarely ever examine whatever the item is personally. They're typically going either from a drive that's been sent to them, if it's digital forensics,
Now,
or
he also said we didn't pay you anything.
see, now that's where I'm seeing a problem.
Right.
That's where I'm seeing a problem. So again, we don't know what the date of the invoice is. Now,
Assuming it's
saw-
accurate that go ahead, you were going to say what you saw.
well, Ashley tagged us. Ashley Oaks tagged us, and it's got an invoice, but it's a DOJ invoice. So I don't know how that helps, because what Brennan said is the defense sent a check for 23 grand and some change. I thought
They got an invoice.
they got an invoice, but they did not pay it.
No, that's all we know is that there was an invoice.
Okay. Sent by ARCA to the defense.
That's definitely what Brennan stated going in, and it's not the same dollar amount, is it?
No, this one was for the DOJ, and this is a purchase order from the Department of Justice. There's no mistaking what it is.
Right.
And it's for $26,000 and $26,011.
And what was the amount here?
I thought it was 23 and some change. What
Might have
Brennan
been.
talked about.
Let's see. I'm listening. A bill from ARCA to the defense,
Okay.
$23,900 and some dollars.
Okay. So almost 24 large. So definitely different amounts.
Right. Unrelated, and it could be a bill for this round of trial.
Give me a kiss.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides.
Did you eat?
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving your report, asked if you'd join us and testify, correct?
That is correct.
All right. Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case as it's
Okay, so that's that, and now we're going to go to when it gets brought up again.
Looking at, again, the evidence in terms of the scene photographs, we know that we have a damaged drinking glass at the scene in the vicinity of the fragments of the taillight. So the theory that Dr. Rentschler and I put forward is potentially an individual threw this drinking glass at the back of the Lexus, causing the taillight to fracture.
I'm going to interrupt you right there. You and Dr. Rentschler formed that theory and wanted to test that theory, correct?
Yes,
You were not told that theory by the defense because you've never met us.
correct.
You were not told that theory by the Commonwealth. You've never met them, correct?
Correct.
Your theory was the product of simply having some facts extant in the data, that a broken drinking glass, a broken taillight, let's put them together and figure out if the drinking glass could be responsible for the taillight and vice versa.
Absolutely, yes.
And that was your determination of, well, we were given instructions to reconstruct this. Let's look at every single angle, correct?
Absolutely. And I will note, as part of the engagement with the entity that retained us, we were asked not to do any outside research or investigation of the case. It was to be based solely on the evidence that we were provided.
Okay. As a matter of fact, and importantly, while you were doing your testing, had you ever even heard of the Karen Reed case?
No.
Okay.
So Annie, that's, your comment is correct in terms of what it was for. If it's for costs, that's fine. But the problem is if the check predates this date, when he just asked Wolf on the stand whether or not they had received any funds at all, retainer or otherwise, cost, whatever the case may be, any money. He asked him, you haven't received any money from us. And the answer is no, we haven't. So you can see where that would be the problem. I find it very, very difficult to believe that Alan Jackson and David Yannetti would go into a court of law and lie about when money was sent to ARCA. So I feel very secure that at this point,
I think that they did say that they paid expenses and costs.
when?
Travel expenses at trial.
Prior to? When is the
Yes.
billing statement from?
I believe that what they said was that they paid travel expenses for trial. And I was trying to find,
Wait, when do you think they said that?
well, that's what was being, when I was on with Melanie, that's what someone who,
Wait, somebody in the chat said some shit?
no, someone that is in the know. I don't know all these things. Said that that Jackson had indicated that he did not pay for their trial testimony, but he did pay for their travel expenses.
But when?
I'm assuming that was before trial.
How are you paying for trial expenses when you don't? Well, unless it doesn't include trial testimony, which
That's what they're saying. They specifically said it did not include trial testimony. It was just for their travel expenses.
it's sticky. This is going to be the shit that they're going to have to clear up, and they're going to have to bring receipts as to exactly. They're going to have to show when they paid that out and what the invoice said, which is a lesson to you out there, all you young lawyers who are thinking about going into your own practice. Those notes, and in terms of your invoices and what you write on your checks, you need to be extremely careful about indicating exactly what it's for and not be loose on the language. So,
Right.
It's a sticky situation with this.
So let's assume that he did, in fact, pay trial expenses before trial to get them there on the 27th, to keep them there until the 30th. Travel expenses, hotel, food, whatever the case may be.
Who did you have on? Did you just have Wolf on right before this Rensselaer clip?
Yeah.
Well, I want to hear exactly what he asked,
Okay.
because I didn't hear anything about him delineating between cost and anything else.
No, he didn't.
I thought he said, we haven't sent you any money.
Correct. He did.
All right, well, that would be a fucking bald-faced lie then.
And I'm going to start it at the beginning because, it seems when you take it all in context that he's talking about in relation to their opinions.
Is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Mr. Yannetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense. Is that right?
Correct.
Conclusions and your opinions are completely independent of the
Why did you
defense
fast
and
forward
the
it?
Commonwealth in this case. Is that
I
right?
don't understand why you did that. He was talking about the money.
Of the defense and your conclusions and your opinions are completely independent.
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You had never met us, didn't know who we were when you did this.
Correct.
You had never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
I mean, what do you think?
That's why I'm saying it. When you take it all in context, I think he was saying I didn't pay anything for that opinion.
You're adding the word opinion.
But that was sort of the way he had prefaced it initially, was about, at the time that you wrote your conclusions.
This could be a problem. I'm concerned that this could be a problem. If that check went out prior to Wolf saying what he just said.
That's not $23,000, I don't think. That's
For two experts?
For travel expenses?
I'm assuming they would have had to pay him for
No.
year, for flying out twice.
Assume no money was paid to them for their time in the courtroom. Just their travel expenses, hotel, food.
Where are you hearing that? Like, since when would ARCA come in without request? Like, they're coming in out of the kindness of their heart to it's where they make their money, testifying in court.
I know. I agree. I've said this before. It's very unusual to have someone sit in a courtroom and not be paid for their time in the courtroom. So it would be bizarre for the defense to lie about that because you assume it. But maybe in their heads, they're focused on this opinion. We didn't pay anything for that opinion. You made that completely independent of us. We paid you nothing. That when you take it from beginning to end, to me, that's what he's saying. But yes, I agree.
Rewind it one more time. Like you changed up exactly what the wording was.
And you don't work for us.
That's correct.
To go to.
This is fine. Like here, what is
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
You said it before this.
Well, goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
Right. You have not been paid by the defense. That wording is problematic. But when you go back, he's talking about
When you did this.
Correct.
Yeah, and we're talking about two experts,
anything to do with that.
not one expert. It's two experts from ARCA, which is the pinnacle. I mean,
Correct?
Correct.
You never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
Right.
yeah. And look, what we're doing here, I'm trying to figure out if Cannoni's going to have a place to hang her hat.
Right.
Don't confuse what we're doing here with me thinking that Ajax should be bumped, because I don't think that he should be. What we're trying to figure out is if Cannoni's going to be able to do it. If there's loose enough language, depending on when that payment came in, for her to say, well, you flat out, because I mean, Alan Jackson's going to say exactly what Allison said, which is probably the truth. You know, when you look at it in the totality of what we were talking about, I obviously was talking about we did not retain them to form their opinion and do the testing. You know, like I wasn't talking about like obviously we had to pay for their travel and to get them here.
Oh,
But
so
like
that's what I
I don't
started
know
to
how that
say,
works.
babe, is that I tried to find the day before this, whenever she said, I want to have them testify, because I think I recall them saying, well, we'll have to get them here. We'll have to change, pay to change their airfare. Like I think there was some discussion. I looked all over. I could not find whatever day it was when she first said she wanted them to come in for the 27th. So
Laisha, you understand that they were paid twice. So that the feds paid them initially, but they were also paid they were paid on two separate occasions. We have two, like I've seen I just want to make sure that you're not confused that they were definitely paid by the defense or they were billed. Whether or not they were paid, I'm assuming they were. Typically, witnesses don't show up unless you're paying for their shit. But maybe because it's ARCA, they're like, all right, we'll do it and then we'll bill you. Alan Jackson's got a very reputable, huge firm. They know that they're good for the money. So maybe they're like, all right, we'll send you a bill after the fact.
no, but
I mean,
that would be dirty pool. That would be a complete violation of everything that is ethical.
wait,
If
why?
they knew that they were paying them, but didn't pay them until after trial, so
Wait,
that they could
if who?
answer the question that we weren't paid anything to provide our testimony here today,
Well, I mean,
that's clear cut.
then
That's clear cut.
how is it any better that he's answering the question he's asking and he's answering the way that he did? I don't see how that's
I
better.
don't know if they consider covering expenses, literally the cost of travel, the cost of the hotel, the
Well, I
cost.
agree with Travis because travel, hotel, and meals for two dudes is not adding up to $23,000.
Right. That's why I don't think I said the same. I do not think that was a bill from the first round. I think that's dealing with round 2.
You mean now?
Right. But we don't know. We don't know. We're going to have to see. But that's my assumption. Because, and I said this again, like when I was on with Melanie Little, that um it's bizarre. It's extremely bizarre to not pay an expert to come into court. There's nothing that would have
The
changed any.
Glare is saying that they never paid him. So are you saying that they got that bill, the 23-9 bill, and that they never paid that out? Is that what you're
That
saying?
bill could be present day right now. Why do you keep focusing on that bill?
Because the bill is everything.
Well, I know, but I'm sitting here assuming that bill is for now.
Canoni should have fucking sat there and asked Jackson, when the hell did you pay him? Like today.
So the Glare is saying the defense didn't pay anything. And I do know at least somebody said in the chat when Melanie and I were on that Alan Jackson said it again to the press that he did not pay them anything. But then there was someone else, and pay attention to the chat because I'm sure there were a lot of people here now that were on Melanie's live earlier. There was someone who heads like a free Karen Reed type thing. I don't know who
I think
specifically.
it's Rocco, Nick Rocco.
Yes, that was his name. That he said that the defense said they only paid for expenses. Now, do I know if he was speaking for the defense or making an assumption? I do not know. But in what world do people pay their own travel expenses when they're not being, especially when they're not being paid to testify? I mean, nobody's coming. And that's why I'm saying I wish if anybody can find me the timestamp for when there was a discussion in court about the fact that Judge Canoni wanted these guys to come in and testify, that she was going to force this voir dire, would have been hearing on the state's motion. And because I think there might have been a discussion right then and there about travel costs or travel or something. But if the Glare is saying the defense didn't pay them, they volunteered and may have been subpoenaed. Yeah, I'm assuming that they were They were subpoenaed. But even with a, you know, when witnesses are subpoenaed to testify, they have to be provided a subpoena fee. That's not something that is considered they've been paid to testify. I don't even remember any case where the witnesses testifying that they've been paid to testify because they were given their witness fee, their mileage fee.
Yeah.
And I had a
This is a frustrating live, and you know why? It's because Judge Bev decided to do what she did today, which is not allow Jackson to clarify. I mean, like, this should have been handled today. You know, like having a fit and going back in chambers for a half an hour and then suspending the rest of the day without letting Jackson clarify, especially after Brennan comes in and does a mea culpa. Oops. Yeah, sorry. That was actually the defense that said the shit. I mean, I don't know.
And Nikki's question, and I mentioned it earlier. Nikki says, what if they were paid by the defense after their testimony? That is a known, you cannot do that. Like, that's known all across the legal world everywhere. You can't not pay someone who's billing you for it and just pay them afterwards, But I will note that I went through the transcript from the trial testimony and the voir dire testimony to see if Lolly ever asked anything about expenses, cost, travel. I didn't see anything. That doesn't mean I couldn't have missed it, but I didn't see anything.
Yeah, it's true. AJ didn't ask to be heard. Like, I mean, all of us could see that she was quivering, and for whatever reason, whether it's anger, anticipate, whatever, it's like, as a lawyer, you're sitting there looking at it. You got to kind of weigh your options. She's already declared she's suspending all of it. She doesn't want to hear any shit. You're walking around as attorneys on eggshells when judges are in that kind of mood. I mean, I don't think Jackson was in a position to where he wanted to kind of push the envelope. I don't know. I mean, I'm sure Alan would have been happy to clarify things today. I mean, clearly they knew it was coming, at least to some extent. But I mean, I do think Brennan ambushed him with this whole thing. That's what I'm saying. Like, they could have filed, Brennan easily could have filed a motion for sanctions, giving the defense the heads up that it was coming, but he didn't want to do that. He wanted to do it the way that he did it. He wanted to try to body slam him with this shit out of the blue, and so maybe Alan was like, all right, I'll take the 6 days to get my ducks in a row, and then I'll come back and hammer this guy. So it's
Right.
funny because, like, I don't know if you saw the interview with Karen and Alan that they did.
Afterwards?
No, they just did it recently. I watched it on Melanie's channel the other night, and Alan was sitting next to him, and he asked him about the relationship that he had with Brennan. He's like, professional. He's like, we're able, we deal professionally with one another. It's, there's no that died today. This is like, after the shit you pulled here today, it's like, it was a total ambush. It was a total ambush today.
Did Blair give another comment? Because Mandy told me to look at it.
I don't know.
But it might be the one we already. (6/10/24) court day. Discussion about Rule 14 violation. I'll look for it after we finish this. After we finish this, I don't see the comment she was speaking about. Oh, the difference, and this is Blair's comment, the difference between these experts and the paid defense experts is that they testified to findings in their independent investigation. The other experts were paid to investigate by the defense.
Yeah, we
And
know that.
once we get finished this, Bob and I are going to reiterate that. I mean, that to me is the end all be all of what makes the difference here. So
You're
let's
right.
listen to this last part.
Of Let me ask it this way. Were you asked to engage in an analysis, ARCA, to be engaged in an analysis of the incident that is currently before the court?
I was, yes, sir.
Did you produce, or did your team produce a report about your opinions and conclusions, including the testing and the methodology that went behind those opinions and conclusions?
We did, yes.
You were not hired by the defense in this case, correct?
No, we were not.
You were not hired by the Commonwealth in this case.
That's correct. We were not.
When you started your analysis, you didn't know who we were. You did not know who the Commonwealth was.
That's correct.
You'd never heard of the Karen Reed case.
I had not, no, sir.
You were contacted by my office after you provided your report, correct?
That is correct, yes.
Were you ever contacted by the Commonwealth?
Not that I'm aware of, no, sir.
And you and I have never discussed the substance of your testimony, correct?
That's correct. We have not.
So, and there was a similar question to Wolf. So, without knowing what's in that questionnaire, it sounds to me, I guarantee if the substance of their testimony was discussed, he would have read it. I think he read out everything that could possibly have been interpreted as a question that did not deal with their history, like their
CV.
their CV, their curriculum vitae, and their prior testimony and deposition.
Right.
Would you consider that your analyses, your conclusions and opinions in this case are completely independent of any party in this room?
Objection.
Sustained.
You've not been paid by the defense, is that right?
I have not, no, sir.
And you do not answer to us in any way?
I do not. That's correct.
You indicated that you and your team were asked to undertake a review of the circumstances. What exactly did you review in coming to your opinions and conclusions and performing the tests that you performed?
Well, we looked at, there was a police report.
I think that was it for that topic. So you talk while I'm going to look and see if I can find what it is I was looking for.
Well, I mean, at the end of the day, so I think what's at stake here, you know, if you're trying to read through the tea leaves and based on that daunting statement by Canoni that, you know, that this could, based on what she learned today from the Commonwealth, this could have a profound impact on the defense team and the defense both. I mean, we have to take that as that she's seriously considering, one, barring both gentlemen, both Rensselaer and Wolf, which would be devastating. And moreover, I think that she's seriously contemplating pulling Jackson's pro Hac Vice ticket. But, you know, as Allie said, there'd have to be a hearing on it. Like there's got to be due process. She has to provide Alan Jackson the ability to be able to rebut the shit that Brennan says. I mean, Brennan, in the short time that we've been watching this guy's the king of not bringing any receipts for anything. He just says shit. He tries to get experts bumped without providing any kind of scientific evidence, no witnesses, nothing. Like the thing that he did, which they were calling with Dr. Russell, that they termed a Daubert hearing, was not a Daubert hearing. That's not what Daubert hearings are. Daubert hearings are your challenging science, and the challenging party has to bring somebody that's not a lawyer, or that it's a lawyer that has a knowledge of the science that is unimpeachable to the point where you could put them on the stand to testify. So typically you're going to get somebody in that field that's going to get on there and say that methodology is whack. That didn't happen. Hank Brennan saying that it's whack doesn't mean jack shit. That's not, and you know, this is the same thing. You know, and to me, the biggest takeaway is that, you know, like I'm telling y'all, like Brennan had plenty of time. He got those things from the defense on the 13th. We're sitting here, what is today, the 17th, 18th. He had plenty of time to pen up a little motion for sanctions with what the request being that Jackson be removed for his lack of candor to the tribunal or whatever the case may be. And, you know, he chose not to do it that way. He chose to come in and blindside him, you know, and I mean, we'll see where it lands, but it's all right. So let's talk worst case scenario for Karen Reed that somehow she bumps Jackson. And then what is the next move? Is it going to be very similar to what happened in the Richard Allen case, wherein, because here there is no question that Karen Reed's Sixth Amendment rights are going to be impacted massively if she removes Alan Jackson, who's without question lead counsel for her defense team. If Cannoni's going to do that, because in there was some question in the Richard Allen case in terms of whether or not when she removed both Bradley Rosie and Andrew Baldwin without a hearing, in total ambush style, she forced them into withdrawing against their will. At least Andy Baldwin did. Rosie said, I want to take it under advisement and I'll draft something so that it's in writing. And, you know, ultimately, because it was either dip out of this case or I'm going to pants you publicly, because this is the only time I've allowed cameras in the courtroom. It was one of the most rogue moves I've ever seen a judge do. And, you know, ultimately the process in that state is that they had to go to the Supreme Court. They skipped a step, which is an interlocutory appeal, which is an appeal that takes place while the case is proceeding. Okay, so that was pre-trial, but the case was underway. They were engaged, but the issue with those two lawyers is they had originally been appointed. They weren't hired. They were not paid. They were not retained as private counsel like Yannetti and Jackson are. So the argument then in that case shifted to whether or not they had moved beyond just because with public defenders and appointed counsel, you don't get to be as picky. And in the current law, which is Allison was adamant about this, which is shifting, had been that as far as right to counsel goes, that public defenders who are appointed didn't fall under that purview. But that's been shifting, especially as the relationship develops, the attorney-client relationship. They were a year into the representation. And then when she removed them, Allie and I kept saying they need to enter their appearance pro bono. Like they gotta suck it up. Because at that point, they then become officially her attorneys or Alan's attorneys, and they're by choice. They weren't appointed. They're no longer appointed counsel. They're because they had gotten an affidavit from Alan saying, these are my attorneys. This is who I want representing me. And ultimately they ended up not even leaning on that. They took it up to the Indiana Supreme Court. They skipped the interlocutory appeal. And the reason I'm telling you all this is if in the event that Alan Jackson is removed, I can assure you he will not be going quietly into the night. The question then will become is what form will the fight take in Massachusetts? Every state's a little different in terms of what's required. Now, he would have to, like in our state and in Indiana, in order to take an interlocutory appeal up, you've got to basically run it by the judge. Say, Judge, I understand what your ruling was. However, I want to appeal it. And the judge basically has to give you the blessing. And then you take it up to interlocutory appeal. In Allen, they felt like Judge Gull was never going to agree to that. So you're like, you know what? We're going to skip that step and we're going to jump right up to the Supreme Court and file what they call an original action. And that's when, they went up there, they argued it, and they were reinstated the same day. Like, so that the court immediately reinstated them. They understood the implications with the Sixth Amendment issue, and they weren't going to mess with it. And in this, it's even stronger because Alan Jackson is retained counsel. Baby, you got to quit coughing right into the mic.
Sorry. All right, I'm going to start this.
Need a cough button. All right.
And they've gotten the substance of his opinion from us. And they've had that for a long time. And the court, I believe, has already suggested that voir dire will be done prior to this time.
What?
Can you set up the clip? What are we looking at?
This is the, sorry, this is the June 10th, where they're talking about the fact that they're going to have to voir dire these experts.
Okay. Thank you.
All right, so it's starting to look like we might need a whole day of voir dire, and I'm trying to avoid that. So is the Commonwealth satisfied that when did you provide anything recently since the filing of the Commonwealth's motion, Mr. Vanetti?
Not on Mr. Vanity, no.
What does the Commonwealth have on Mr. Vanity?
On Mr. Vanny, all the Commonwealth has is what's contained, the synopsis on page 2, the first full paragraph. We do not know what his opinions are. It says he'll testify regarding his opinions and conclusions about reconstruction and EDR data obtained in connection with this case. He'll testify to chronological data derived from the EDR, including key cycles and triggering events from the time period in question. I have no understanding or information about what chronological data he's going to testify to, what his ultimate opinions are, anything beyond that relatively vague synopsis that does not comply with Rule 14.
Okay.
Similarly, what's outlined in the rest of the motion, that's all the expert evidence the Commonwealth has received from the defense is contained within the Commonwealth's motion.
Okay, so the defense needs to provide, I'd suggest you listen, the defense needs to provide what chronological data Mr. Vanny relied upon and exactly what his opinion is. All right, by the close of business tomorrow.
That's fine.
All right. Now, regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
We can't, Your Honor.
So
we can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for a voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER doc. Is she an ER doc? I haven't seen her. She's not a pathologist,
Well,
correct?
she's a pathologist, but she has a lot of experience in an ER, which is.
Wait, now I thought there was something more about, hold on.
Let me see. I wanted to. There was a question I marked.
So, and the person asked the question about where was this order? He did just say that it's been briefed and ruled that they couldn't speak to us. So I don't know where.
Why?
Convictions
We can't, Your
testify to.
Well,
And you have not complied with your Rule 14 obligations.
We can't, Your Honor.
So,
We can't.
so you can't, but you haven't. So I am left with you haven't complied. So we can't be.
Testimony and their background. That's it. That's a rule that they put TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense.
It was specifically outlined that and ruled that they could not prep with us for trial.
So maybe that was a federal court that ruled that. Good. You were going to mention someone else's comment.
I mean, they did prep with them though.
Well, he said that was just to get their background.
No, but I'm talking about the damn outline of the direct.
Right, but he's saying that was just about their background. If it's more than that, that's where I'm saying I think Brennan would have read everything that wasn't about background. I think we heard everything, which was a lot of accidents happened at night, and they put that he testified to it, so they didn't keep it out. They didn't do anything sneaky. And two, they're going to make a big deal that I didn't, you know, uh, see the vehicle or go to the scene, whatever the statement was, and that's not unusual and it's not a big deal, and we need to let the jury know that that's not a big deal.
Wait, dude, you're confused. The entire point of the discovery is that they don't learn about that at trial, which is what we watched. That first came about for the Commonwealth's purposes at trial. I mean, that's what Brennan's arguing, that
Yeah, but that would
he
only be
testified
come into
to it.
play if it was something beneficial to the defense. Him giving his general knowledge that accidents happen at night, that they did not need to know that ahead of time, in my opinion.
But
And I don't think it's the
that's not what
substance.
you said. You said that they didn't do anything sneaky. I mean, they
I
knew
don't think
he
they
was going to
did.
say it. Well, that's a different thing. Saying that you don't think that's discoverable material is a completely different thing. And I agree. Like, as far as experts go, I mean, you don't have to give a word for word blow by blow as to what they're going to testify to. You have to give what their opinion is and what the basis of that opinion is. You don't have to give a script of what your entire direct or cross is going to be if somebody's expert witness. It's obscene. So I expect from AJ he's going to come in with receipts. You know, I mean, from his perspective, he probably didn't push it with Judge Bev for one, you know, her mood, but two, more importantly, so he could get all his ducks in a row. I mean, the man is
But yeah,
legendarily prepared. You know, I mean, they are a very prepared defense team. And by the way, I want to restate Yannetti's my favorite. I love when David Yannetti argues. Like, my favorite thing ever was his argument on the motion to dismiss was phenomenal. And then Greg had asked, I asked this on a couple of streams, but I'd like to get multiple inputs. Let's say it's proven that Brennan misrepresented all of this, or that he flat out lied. What ramifications could there be for him?
I would say
Sanctions.
whatever the hell she's about to do to what she got all shaky and worked up about for the defense, there's going to be grave consequences.
Yeah.
You know, appoint a public, a private, he is a special prosecutor.
Right.
But, you know, the thing here is he did only he did lie, and I think he's going to say he was confused. But you
I don't
have
know how he says that when he doubles down with the whole, you know, I
right, and
got it through the TUI request. Like,
and then
how
he
is
had a chronology written out
right.
later, written out with the dates. So, but there's got to be a line between I'm incompetent and I'm a liar, because, like you said, if he wasn't playing gotcha, if he wasn't trying to like have his, what Melanie kept calling, drop the mic moment with all of this, he could have. I can't for the life of me believe that there is a bill out there that exists without the dates, of what
Not a
they're
chance.
right.
Well,
So,
I've never heard of an email that doesn't have the date on it.
well,
I
I think
mean,
the
every
email
header has
contained,
the date.
I think the email contained this printed out outline of questioning, and that outline didn't have a date. They don't know when that occurred.
Oh, right. So, I mean, but Jackson will be able to provide that in terms of when it was created and when it was sent back and forth between him and Wolf.
Right. In other emails. Right.
So, I mean, like, yeah, I mean,
But
the answer,
so for
Greg,
that, I don't
the
think
goose is good for the gander. You
right.
know,
But I don't think it's going to be. I don't think
she's
it's
not
going
going to
to
do shit to Brennan. That's the answer. To, like,
Right.
we know she wasn't outraged by the inverted video. If that didn't outrage her in terms of the Commonwealth being up to some shady shit, like, I mean, everybody that watched that case expected her to lose her shit. Like, oh, well, this is finally the time she's going to lose her shit on the Commonwealth because that's some shady shit putting in an inverted video. If she didn't lose it then, she ain't going to lose it now. So don't hold your breath.
I just don't know. Does she have no self-awareness to see that she responded like this when the first question of the defense comes up and, you know, all the issues with the law enforcement and the Commonwealth, and she never said a word. She never, ever,
Well,
you
that's how
know.
everyone says she's biased. You know, I mean, like, I look at end results in terms of what she allows in at trial as the gatekeeper. Like, that's what matters most to me, as opposed to like her not admonishing people. I mean, I'd like to see it. But in terms of, you know, like, and again, you know, we're deep into Delphi over here. So, like, I saw a judge in that case that was exceptionally biased. I mean, she shut down the third party culprit defense in that case that all the Karen Reed people would blow your fucking minds. That would have been like if Judge Bev had said, "Nope, I'm not letting any of that shit in.
Right.
Good luck." Like
And I
that
wanted to
that would have been the equivalent to what happened in the Richard Allen case, because that's exactly what did happen.
and I wanted to thank Ariel for that.
Yeah, thank you for digging that up, Ariel. We appreciate it.
I mean, I'm sure she is somewhat stressed, but I'd venture to guess, depending on what the full story here is, that her lawyers told her this is nothing, don't even worry about it.
Yeah,
Like,
don't worry. Like,
we've got our receipts, and there's been nothing
she's
on
still
that.
going to be stressed, though. I mean, you know, if there's like a threat that Jackson could get booted from the case, then, you know, but I mean, Bev's going to have to realize if she's going to pick that fight, Jackson's going to throw down. You know, I mean, he, like I said, he is not walking quietly into the night. There is a 0% chance that he is not fighting to get back on the case if she removes him. And it's going to be a lengthy road to hoe. I mean, I think that they'll put that means that the April trial date's getting kicked 100%. If she removes Jackson, this thing's not going to trial in April.
No,
I promise you that.
that's for sure.
So
And did you do a Hank impersonation as Lisa requested?
wait, I already did one
Oh,
earlier.
you did do it. Okay.
You're gonna have to rewind, Lisa. You
No,
get that.
that was me pulling up something that was said before.
Oh yeah, I mean, you know, you guys will get plenty of Hank impressions during the trial. It's like my Lely objections were pretty legendary. I had nailed that.
So let's talk real quick about the other motion that is pending that came up today about the pro hoc vici status of Betero.
Yeah.
You had mentioned before that you thought that there was a potential conflict. I poo-pooed it, like, I don't really see a conflict because of all of that. But then today, and I guess I could play that part.
Yeah, play it.
Okay.
You really only have to play Brennan. Like I've never seen a dude who talks out of both sides. Of
Yes, that's what I was gonna say.
Dude, like, oh, I have like Karen Reed's allowed to have as many. I want her to have all the lawyers she wants. I don't like, but Your Honor should really look into this. It's like, you know, I'm like, what?
Morning, Your Honor, Laura McLaughlin for the Commonwealth.
Morning, Ms. McLaughlin.
Adam Allen for the Commonwealth. Good morning.
Good morning,
It was
Mr.
crazy.
Valley.
Good morning, Your Honor.
Yeah, Ashley, we were talking about that. That's the writ of habeas
Morning, Mr.
corpus that they
Jackson.
filed
Morning, Your Honor, Elizabeth.
over in the federal courts regarding the motion to dismiss.
Your Honor, Robert.
That's worth litigating.
Good morning, Mr. Alessi. Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, I was told council wanted to see me at sidebar.
Agreed. I mean, people that have only been following Karen Reed and have not been following Richard Allen's case are going to be like, you're nuts. No, we're not. Gull is a whole nother level of bias. It's like a whole nother level of bias. I just can't wait until the appellate court. And if the direct appeal doesn't work in that case and they go up to the Supreme in Indiana, but I don't know what the Indiana Supreme Court's going to say. They didn't boot her when they had the chance. All right. Is this it?
Yeah. Hold on.
I hadn't seen David argue anything in forever, so I was happy to hear his voice.
I was also shocked about the judge Oh, and what she said about the motion before he chimed in. So I'm going to start with that.
The next one should be fairly quick and simple. The motion for Pro Hac Vice. I asked you before when Mr. Alessi joined us, you have a rather vague, good cause exists to grant this motion because Mr. Betterow had, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that. I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
All right. So she was about to allow it. She said it twice. She said, give me more details and I'm likely just going to grant it. And then I'm going to grant it on the papers. And now let's hear Bob's double talk reference here of Brennan.
Thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel? Thank you, Your Honor.
Okay, the next one's paper.
Maybe her brief.
Yes.
Oh,
He just sits there.
Yes.
May I be heard, please? Thank you.
I'm going to play dirty again.
So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want.
It's not an opposition.
It's not
But
an opposition
here
per
comes
se.
But here comes my opposition. What is it, babe?
Huh?
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 Is it an opposition?
Per se.
Want to share with the court.
Okay.
It's
know
not
what
an
you wanted.
opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice.
And
That
so
being said, as you
I'm going to sit down now.
Right.
So, Your Honor, for those reasons, I say nothing further.
Right.
are
I just
made
wanted to say
aware-
that.
I'm big on the Constitution, Your Honor. I just wanted to say that Miss Reed should have all the lawyers she wants.
That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a
Oh, no. A relationship between attorneys? You don't say.
Oh, no.
That can't be.
Shilling,
For sharing information?
shills.
I was trying to find the. Late, but there you go.
a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case, that there's an ongoing long-term implicit mutual assistance and mutual defense that they've
Yeah.
been a part of for a long time.
You see Ian on
The Commonwealth is
you see Aiden sitting right there in the front row in the foreground here.
Is that
See his
him?
computer? Yeah, he's watching Ian. Ian played his interview with the juror. So like Aiden's sitting there watching Ian, who by the way is going to be on our show on Thursday. We'll be talking about Reed for sure with Ian. Runkle's going to be here Thursday. So make sure you're checking that out.
All right. So, and I just want to note, there is nothing unusual or torrid about lawyers with cases that overlap working together in a symbiotic relationship to share information and help each other. That's very, very normal. And he knows it. He's a defense attorney.
Not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because
I'm going to stay out of it. But you know what the court could do? It could delve into all of this shit.
as we'll later talk about in a sanctions motion, a violation, a direct violation of protective orders in this case. In the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow will be serving two masters. He will receive protected information
There's your conflict language. He will be serving two masters.
in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. And so we know this relationship is substantive. We know it is a deep
substantive.
relationship.
It's deep.
The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so
Who's
while I
staying
do not object
completely
to
out of it.
Attorney Betterow, they
While I do not object,
should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial. And the witnesses are entitled to walk in this courtroom without being abused. Thank you.
and
Okay. Ms. Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge.
I mean, is it possible that she was not aware that Betterow was not repping Aiden?
No. How?
Maybe I don't she's like, she did the whole Betero, is that how you pronounce his name?
like that shit. And that, because remember, when the issue of Aiden was brought up pre-trial, she was very much of the mindset. Like it almost sounded like, because both sides said we're not bringing him up, and she was of the mindset that, well, if he's mentioned, he's coming in. Like she is. I could see. That's why I told you when I first heard that Betero was filing his pro hoc motion. I'm like, if Bev puts it together, who he is and who he's repping right now, it's potentially going to be a problem for Mark getting in. Like, I'm just saying, like, do I think it's right? Not necessarily, but you got to look at the history. You got to be able to, like what we're trying to do over here is make predictions on the way shit's going to go.
And I think that the issue is going to be, we know how she feels about the harassment of the witnesses. She wants the witnesses to feel safe. So that could be something that keeps her from allowing Betero in. But as I said earlier, she could say he can't cross-examine any of the fact witnesses, whatever.
I mean, I like to be honest, you have to worry at some point that it's a too many chefs in the kitchen type thing. I mean, they've got 4 very competent lawyers in there right now.
Yeah, I'm not
That
sure.
all seem to have their roles. I mean, I think we'd all agree Alisi is certainly the tech and science guy. He's going to be handling all of that. You're going to have Yannetti if they're going to be pursuing the conspiracy angle again, which it very much sounds like they are. Yannetti and Jackson have that in hand. I don't know what the role will be. I mean,
You'd almost think the role would be exactly what I was just saying the judge might do and say he can't cross-examine the,
who does that leave, though, is my point. Like, that's
right,
what I'm
because
saying.
you'd think that was probably Bettero's role, was to keep track of all the communications between the witnesses, the what do you call them, McAlberts?
It's not what I call them, but
Well, that's what
they're referred to as. So yeah, I mean, there's a lot of moving parts with an April court date, kids. I'll tell you that. A lot of shit going down. And keep in mind that I believe she extended Jackson's deadline for filing their motion to dismiss. I believe it's the 25th. It was originally the 21st. I think she gave him 4 extra days. Now, Jackson's got to make his way back to Massachusetts after we heard him saying that he's got a hearing on the 24th. They're trying to pound this thing out. That motion to dismiss is still hanging in the air. And now they've got this shit hanging over their heads. It's a lot.
their response is due February 28th, 2 days after they get it.
She gave the Commonwealth.
No. This is the federal court. The federal court gave the state, the respondent in the federal case, until Wednesday, February 26th to file an opposition brief, and the petitioner shall file a reply brief 2 days later, February 28th.
Wow. That's like,
so this takes, at least this is taking place before that and not in the middle of it. And that might have, I don't know what time.
I mean, they're going to expedite the thing. That's for certain. Clearly it's been fast tracked.
There's no time. I don't know.
I mean, it's got to be fast tracked. To me, like that it is such a perplexing issue, because I mean, I have no reason to not believe what Ronnie said. And I don't know, have you still not watched that interview with the juror?
No.
I asked Aiden today. He said he was cool with us. Like, I want to go through it like Runkle did, because it's very enlightening. It's very enlightening. I mean, the dude was super candid, super honest, said a lot of things that should really scare both sides, and both sides should use it as a tool in terms of determining, okay, this is what we need to batten down the hatches with. And from the defense side of it, they need to make a concerted effort to make sure that the jury understands the concept of reasonable doubt and what it is,
Right.
because it was very apparent and it was very clear that all 12 of them voted not guilty on 1 and 3. Like the guy was unequivocal about it, and and he wasn't like behind a screen, like he was
Right.
sitting there, gave his name. It's like the dude had some sack and was there, and he was pretty candid. So yeah,
Yeah,
there's
we'll do it. We'll do it.
yeah.
We'll bring it to the people. And then Angelina asks, can Betterow do the work behind the scenes? The answer to that is yes, always. But I don't think that the judge can trump her right to counsel of choice with the potential of them feeling harassed by a lawyer doing their job.
You need to look up
That-
the pro hoc vice statute in Massachusetts before you say that. That could be 100% discretionary, because she can easily say exactly what I've just heard a judge talking about on another pro hoc application when we were I forget what we were reading. They're like, there are plenty of attorneys, fine attorneys in the state of Massachusetts that you can retain that don't require you to go and bring in an out-of-state lawyer. So, I mean, if it's discretionary,
Right, and I guess that's why she's asking for more details, because I found that strange. Like, what do you need more detail for? She wants this lawyer, you know.
yeah,
I mean, I've never been asked to provide, a reason why my client needed me, and we've done a lot of cases in other jurisdictions.
yeah.
Even federal court. I've never had them asked. They just grant it as a matter of course.
Yeah, I mean, it's usually rubber stamp. It's usually
Yeah.
rubber
And she was prepared to rubber stamp it before he didn't object.
I mean, kind of, but not really.
No, she said she was rubber stamping it on the papers.
Well, but she still brought up the affidavit was relatively vague as to
Right.
what
And she
it
said,
is.
as long as you round that out and you give me some reasons, then I anticipate granting it.
I
And
mean,
then
but
he
why
said
does
on the,
she really have to give? Why does he have to give reasons? That's who she wants to bring in.
like you said, it must be in their something in their statute that, like you just said, what makes him different than any other lawyer in Massachusetts that you need to go out of state. But yeah, in my experience, it's never been asked of me, like, why you?
Yeah. Yeah.
Over and above, I'm the lawyer that they want. And I've
All
got a
right.
lawyer.
I mean, look, let's summarize. I think that there's a remote possibility that she could pull Jackson's pro hoc. And if you guys don't know what pro hoc, we keep saying it. If you're not licensed, you have to be licensed in every state that you practice in. Now, there's an exception to that rule if for a one occasion only, or per one occasion, you can apply to a state and their bar and say, hey, I want to come in and try this case.
You're
Every
sponsored
state
by a
has
local lawyer.
yeah, I mean, they all have different rules. There's all, but a lot of them will say you have to have a sponsor from, that state who's a barred attorney in that state. But it's typically, like Ali was saying, it's rubber stamp type situation. As long as you have that sponsor, it then sometimes it begs the question, like for us, when we got pro hocked into Omaha, we didn't want our local counsel. We had no intention on having them try the case with us. So it was a perplexing situation, because in terms of like how much do we pay these guys, because we don't even want them sitting in the courtroom. We really just wanted them to sponsor us and go away. So here obviously I'm assuming Yannetti is the sponsor,
Right.
and Yannetti obviously is very much part of the team. So yeah, I mean, a lot of scary shit going on. I mean, if you're Karen, you're not feeling great about today. But like Allison said, I'm sure that Alan told her, look, don't worry about this shit. Like, it's going to be fine. But it lurks in your brain. Like it's her life that's hanging on the, it's on the line right here. So, like she didn't want to walk away from this day. She was probably nervous about how this thing with ARCA was going to go to begin with. and then it took a turn, that made it even worse. So now it seems what the looming threat is, per Canoni's own words, is that she might have a problem using those witnesses as they might be barred, and she might be in peril of losing one of her lawyers. So, a nerve-wracking day for Karen Reed for certain. So, but we're not going to have to wait long.
Z asks, what Bev loves a compromise. What might she do short of pulling Alan Jackson? She could hold him in contempt of court. There's lots of things that she could do, but she was the one going off half-cocked, knowing she didn't have all the information, knowing that she only heard one-sided information, saying grave consequences for this defense and the defense lawyers.
I think the word was profound.
Profound.
Which is even worse than grave in my book. Or she could fine him. Like, there's a lot of ways that judges can ding, sanction attorneys that doesn't rise to the level of booting them from the case. Because I'm just telling you, it's a big deal. That it's got Sixth Amendment implications for Karen Reed. She has an absolute right to counsel of her choice.
And he's already been established, unlike Betterow, who she doesn't have an attorney-client relationship with already. She's got an established, constitutionally recognized attorney-client relationship. She's got the right to that lawyer. And just because he's pro hoc vice doesn't mean she can willy-nilly pull it. There are going to be, it can't just be like, nah, I don't want to. Now, can it be that way in the beginning before the attorney-client relationship? There's different, it's a different burden there. It's a different situation that you need to consider. Here, it's depriving her of her counsel of choice, of her continued right to her counsel of choice, or I'm sorry, her right to continued counsel of choice. So this is not very easily something that the judge can do.
It's one of the most sacred rights we have as, citizens in this country. If you're a defendant, it's a big deal. This is not an easy thing for her to pull off. So
no, and like Bob said, it's not going away. If she actually does this, this is not going away. It's getting appealed interlocutorily, and there's no trial happening in, when is it? April?
Yeah, early April. Annie, this live was actually cathartic after today's chaos. Thank you for all you do. Yeah, the live was a little chaotic, but it mimicked what happened in court today, because we're trying to figure out what possible way she can bounce Alan Jackson.
And what part of what she heard got her so
they didn't turn it over. It was Brennan's misstatement or his flat out lie, whatever it was. I don't care, frankly. It was sloppy or it was intentional. Either way, it was shitty, because then he doubled down talking about how he got it through his TUI request.
Right.
I mean, it's like,
but either way, they did not disclose it before the last trial.
It was ambush shit. So it was all right, y'all. We've been working like rented mules today. We adore you. Thank you so much. Please, 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 please make sure you hit the like button, smash that thing on the way out. It's free. And it really helps get our channel out into the algorithm. We think that we need to be out there. We want to hit 40 sooner rather than later. And we've had a couple of good days. Yeah, that. We do. We put a lot of work in, and we think we give you guys some pretty decent information. So, and we got a great community here. So all those things.
Thank you guys all for your generosity, your super stickers, your comments, and your subscriptions and memberships, all that. Thank you to all the mods. Thank you, Tracy and Mandy. Thank you, everybody. We love you all.
We do. And because without you guys, I'm just an old man
talking about a lot of cases.